Mr. Rouzer, you're recognized for your testimony.
Thank you, Mr. Chairman, Ranking Member McGovern, and members of the committee. It's great to be here with you today, and I'm here in support of H.J. Res. 27, and I urge the Rules Committee to grant a closed rule for this resolution. I'm proud to say that more than 170 of our colleagues here in the House have joined this effort as co-sponsors on this legislation introduced by Transportation Committee Chairman Sam Graves and myself. The unfortunate reality is that this resolution is only necessary because of the Biden administration's decision to publish a new definition of waters of the U.S., or WOTUS as we call it, under the Clean Water Act. In our view, this is a very misguided decision, and it's important Congress ensures that this ambiguous and overreaching WOTUS definition has no force. Without question, we can be proud of the Clean Water Act's success in protecting the quality of our nation's rivers, lakes, and streams in the 50 years since its passage. However, despite the benefits the Clean Water Act has delivered, its history has been wrought with a tortured past stemming from regulatory headaches and overreach from bureaucrats, all because Congress never defined what a, quote, navigable water is. Many times, this combination has led to uncertainty for individuals and what I'll call the more formal regulated communities. And it strikes me there's a fundamental principle that should always apply and guide the crafting of any type of regulation. It should be simple, clear, and easy to follow. Regulations should carry out the intent of the law in a transparent manner and leave no wiggle room for any bureaucrat to substitute their own biases and hijack the process. And unfortunately, that's not the case with WOTUS. I've said it plenty of times before and will continue to say it as long as it's the case. There's no greater example of bureaucratic overreach under the Clean Water Act than the long-standing regulatory ordeal of understanding and complying with the definition of WOTUS. We've heard plenty about this WOTUS definition problem, including from stakeholders across the country at a Water Resources and Environment Subcommittee hearing we held last month. In that hearing, we heard how years of regulatory headaches and fees can slow or halt progress on affordable housing projects, as well as the development of critical infrastructure. Farmers are unsure of what they can and cannot do with their land. In my district, for example, frequent storms can cause water to linger in areas that shouldn't be considered wetlands, and they do not affect any flowing body of water. But the inconsistency in the law's interpretation, combined with fluctuating weather, promises constant headaches and legal wrangling for projects that not only benefit North Carolinians, but for everyday Americans all across the country. The definition of WOTUS is important for a number of applications under the law, including state and tribal water quality certification programs and pollutant discharge permits. Additionally, this definition is used to determine who must obtain a permit for dredge and fill material under Section 404 of the Clean Water Act. The process for doing so is notoriously expensive and time-consuming, and at times has been weaponized to halt projects that some just don't want to allow, regardless of the merits. The penalties of a homeowner, road builder, or farmer, to name a few, if they modify water and the area is later determined to be a WOTUS, they can be subject to staggering fines of tens of thousands of dollars per day or even jail time. Just ask our friend John Duarte from California. Broad and ambiguous definitions of terms such as significant nexus provide trial lawyers plenty of incentive to file suits against farm families and others that might be deemed to have violated the Clean Water Act, albeit totally and completely unintentionally. So I was heartened when the Trump administration released the Navigable Waters Protection Rule, or NWPR as we call it, back in 2020. This brought clarity and predictability to the nagging question of what is considered a WOTUS while balancing state jurisdiction with federal responsibilities. Under the Trump rule, temporarily flowing water was not included as a navigable water. The NWPR provided certainty and consistency in its application. And so we were quite disappointed when the Biden administration charged ahead with their WOTUS definition, releasing it on December 30th of last year, I might add, in the middle of the busy holiday season. And in addition to that disappointment with the content of the rule, I'm particularly concerned that they have forced it on the public at this specific point in time. For in October 2022, the Supreme Court heard arguments in Sackett versus EPA, a case which has the possibility, not necessarily probability, but possibility of clarifying what a WOTUS is and could render many elements of the Biden rule inapplicable. Common sense which would suggest the administration wait to see what the Supreme Court decides before ramming this rule through. Now, my friends in the minority have said and are likely to say again that passage of this CRA will somehow create further uncertainty if the court creates a new test. This CRA simply prohibits a substantially similar rule from moving forward, but this would not prohibit the administration from issuing a separate definition that is not substantially similar, and particularly and hopefully one that would bring clarity and consistency. Now, given the Biden rule will go into effect on March 20th, Congress needs to pass this resolution immediately. Now, in closing, and this is important, and to take a somewhat complicated subject and state it plainly and clearly, this rule is the equivalent, and our friends on the other side won't like it when I say this, but it's true. This rule is the equivalent of a nuclear warhead aimed right at our farmers, communities, home builders, road builders, private property owners, among others. The ramifications of its implementation will be far and wide, affecting the prosperity and economic opportunity of all Americans. And as of March 20th, that nuclear warhead is going to be launched. Once the federal government has complete control over the definition of a water because of an arbitrary and inconsistent definition of WOTUS, it will then have control over everything else that is applied to that land or that is on that land, whether it be application of pesticides or herbicides or the building of a fence. Farmers, homeowners, communities, literally anyone who owns property could be prosecuted for these simple actions by bureaucrats who have a different view of the world, such as in cases like Sackett versus EPA. This WOTUS rule, the Biden WOTUS rule, will do nothing to bring forth certainty and consistency, as they say, except for the trial lawyers and radical environmentalists who are most certainly consistent in their work to shut everything down. Again, I urge support of HJ Res 27, and I welcome any questions. I yield back.